Karen, can you hear me okay?
Yeah,
All right, great. Well, we should have a lot more people joining. They usually come in,
later.
yeah, right around the top of the hour.
Okay, that's fine. I figured that one time after I missed most of it, I should be early
It'll be
signing
good,
in.
yeah. And
Yeah,
we record everything so that, missing doesn't hurt anybody, right?
yeah, well,
So I want to make sure that they get their questions answered. There hasn't been much movement, unfortunately, as it relates to the overall case. We just keep adding more people to it.
oh, okay. Well, that's a good thing, right?
Yeah, that's true. Yes.
Is
Uh,
the government shutdown impacting that forward momentum?
Some of I mean, everybody, even in the court system now, they're working with a skeleton crew, which is not great. The the judges are still getting paid, is my understanding, but like some of their clerks, some of the admin staff, they are furloughed. And we've gotten emails from pretty much every court in the country now that they're doing, basically they're doing stuff they have to do under the Constitution, like criminal defense. Well, but my Court of Federal Claims, doesn't have a criminal docket, so they don't really have anything that's constitutionally protected.
Yeah. Oh boy. Yeah, well,
And I mean, some of the agencies that we work with are shuttered and others are working. It's hard to know. Like the Small Business Administration is not doing very much, but other agencies are.
yeah, yeah. Well,
We'll see what happens. Give everybody a moment to jump on.
okay.
Um, and if it's just you and me, I'll answer whatever questions you might have, and then we'll call it a day.
I don't think I have any questions. I think they've all been answered pretty much. I just tune in to hear what people have to say.
Yeah, I mean, why I like doing this so much is that the questions that people ask very often gives me an idea of the unasked questions, like,
Right.
so I can expand on those and like pull on that string and see what other questions we can answer, get it out in the materials, and then, talk to the staff that's talking to people.
Yeah. I think the only thing that came up for me was the uh when you show up for a hearing and it gets canceled and you
Yeah, the
don't know until
$5.
you get there and I get $5. It's like, what
Yeah.
is this gonna do?
Yeah, that's actually going to be part of your overtime and minimum wage side of it. So that is and my what I've pled to the court is that is and I've included that in my pleadings, that very activity you're talking about, where it is like you guys could be there for 5 minutes, or you could be there for, an hour, and the ALJ just decides to cancel the hearing because they usually want to give the claimant an opportunity to show up for the
Yeah.
hearing. But then if they don't, or if an ME doesn't show up, or a VE doesn't show up, or there's some other thing that can bog the whole thing down, in the ALJ, even though you guys have been there and you've started creating a record, but the ALJ uh, terminates for whatever reason, then
Yeah.
you guys are stuck with $5. And it's, obviously it's outrageous. And then as I've gotten into this more and more, I've learned about folks that not only were at the hearing for 10, 15 minutes, or more than one human has told me that they had to drive an hour or 2 hours to get to the
Yeah.
hearing.
Yeah.
And they didn't
Yeah.
get compensated for any of that time.
Yeah, yeah, because I rode the bus in. The bus is $6 round trip. So, like I said, $5 is not, I mean, it's helpful, but
You're losing money on that scale.
yeah, and I could have been at home doing, I don't know, my finger up my nose or something
Right,
instead of
right,
sitting there.
exactly.
So that's one thing that I did not include in my summary to
In your narrative, yeah, you can
yeah,
always
because
go
I
back
didn't
and
even think about it.
you can always go back. That's the whole reason we're keeping it running. You can always go back and update the narratives.
Okay, I'll have to go through my paperwork. It's a good thing I didn't throw all that stuff away.
Yeah, and again, I always want to make sure we emphasize that it's not imperative that you have documentation to back up everything you say,
Yeah.
because remember, the agency won't have any.
Well, I mean, if I don't remember it and I don't have documentation, then I can't claim it.
Well, if you can, yeah, if you can't, I mean, it's basically that's really the test. Anything you can remember, you can include.
Yeah, yeah. Okay. All right.
We got more people here now, so
Yep.
won't just be Karen and I. Um, so yeah, I jumped on a little early, folks. You're gonna notice a slightly different background if you're just joining today than you have in other meetings. I'm in my office today. Um,
Okay.
so I'll maybe let you guys see him. Jason Lambro is in town. He's shooting some video for me because that's his background, is what he does. So he's shooting some video for the website, and for this case so that we can help educate people on the Lambro case. So him and his videographer partner Daniel are here. So
Okay.
you may hear them in the background. They're trying to be quiet, but we're getting some footage.
Okay.
We're thinking about maybe trying to raise the visibility of this thing by way of a documentary
Oh,
on the case. Yeah, it's for most of you, many of you, like it started in 2024, but for some of you folks, it's been going on since prior to 2015.
yeah.
2013 for some of the folks at Voice of America, because that's when the Office of Inspector General started a agency-wide investigation into Voice of America's employment practices. And honestly, if it had not been for that investigation, we might not all be here.
It is grounded this morning as Americans try to check in for the flight or
All right, I'm going to use my godlike powers here. If hear anybody's mic is live, um, I'll go ahead and mute you. We'll do what we typically do. I'll give everybody till about 10:03, 10:04 to get into the meeting. I'm going back and forth between folks who've joined through the registration link and folks who've joined through old links. I'm letting everybody in. Then my typical format, I'll give everybody a 2 or 3 minute background shtick on the case itself, when it started, what it's about, what it's grown to include. And then I'll open it, like I always do, I'll open it to questions. So everybody should notice at the bottom of their screen, there's a little hand about the middle of the screen at the bottom. It says raise hand. You can click that when we get to that stage, and we'll be able to, I'll be able to call on you in the order in which you raise your hand. And we are recording today's meeting. The recording itself will go up on the US GovRights website, which I will post for everyone's edification now. That's where we post videos as a resource so that people can learn about the case, get their questions answered. We also have a staff of humans, my wife included in that group now, that is going through your questions as you post them online. So for everyone who joins the case, you'll have an individual portal. That individual portal is your direct line to me individually and to the other members of the team that I've added to the portal and within the Whitcomb Selinsky / Forrester Haney ecosystem. There's only one paralegal over at Forrester Haney who's seeing the questions and fielding them. Most of the questions that person will answer will have to do with like Forrester Haney's involvement, which, for everyone who hasn't heard me say this, it is for the benefit of they're basically doing administrative and paralegal work for me, getting paid by me when this case is over out of a portion of the fees we collect from the government, connected to prosecuting their claims. So again, the under the Fair Labor Standards Act, if we prevail at trial, then the government is the defendant, in this case, the government, is responsible for paying the attorney's fees associated with prosecuting this claim. If instead of going to trial, we end up, getting a settlement that everyone agrees to, then attorney's fees would be incorporated into that settlement amount as well. That would be part of the negotiations, in other words. So I see that it is 10:04. I'm going to kick off. It looks like we have about 10 folks total right now, which is it's a light Sunday, but I'll confess that in this particular instance, I did not do a lot of promoting for this webinar as I have done in the past, because we hadn't had a lot of developments from the court side. The last sort of feedback or pulse that we got from the court was at the end of September, when the court reporter asked me in an email for some information related to the cases that I cited to at the last, on the 7th of, on May 7th. So for everyone who's new to the group, the last time that I had a hearing on this case was May 7th. That was at the Court of Federal Claims in DC. My name is, for those of you who don't know me, my name is Joe Whitcomb. I'm lead counsel on the case against the United States of America. There are actually two cases that are running in tandem or in parallel to one another. One is titled Lambro versus the United States of America. The other one is titled Jordan versus the United States of America. That second case is where almost all of you are opted in to that case and are joined in that case as opt-in plaintiffs. That case is the case we had the most recent hearing on June 7th. For everyone's benefit, what's at stake there is not the misclassification or overtime piece or minimum wage. What's at stake is how far back we go. I'm arguing that that this case should be able to go back forever, back to the earliest time that the earliest plaintiff that joins this case became eligible for overtime. The reason I'm arguing, the legal argument I'm making on that front, is that the government actively worked to hide everyone's rights. And if they've acted to, and because of that, under the case law, the statute of limitations should never run as a result of that. So that's one of the arguments. The other thing we're trying to get done is what's called the initial certification of the case. Now, what that does is creates a notice that we get to do some discovery with the government once the court issues that order, and get the names of people that we haven't gotten through. Everyone who's in this case right now, just for everyone's benefit. Yeah. So once Ignatius asked a question, Joe, I'm hearing about the Jordan case for the first time. Are we all automatically on that case? The Jordan case, it was filed in August of 2024 on the heels of the Lambro case coming out of appeal. And yes, all of you who have signed documents opting into the Lambro case and the Jordan case. Some of you, when you saw the original quote unquote Jordan case, may have seen it called Burke. Burke is also a named plaintiff on that case. The court, not me, decided to call it the Jordan case. I think it just took the first name on this case and called it the Jordan. But right now there are literally 240 plaintiffs on that case. And that is the case where we are arguing to be able to go back in time to, for some people, it would, if I'm successful, we'll be going all the way back to 2002. Jason is an example. He doesn't mind me sharing this because he's here today in my office. But Jason is one example of a person who joined Voice of America in 2002, worked as an independent contractor all the way until 2020, when the agency sort of unilaterally moved everybody over to PSCs. But then I've learned in the last year, I've learned about the existence of VOA, POCs or so the POVs is one that they've got. Basically, none of these are official terms. These are all terms the agency made up. POVs is one of those. PSCs I've already known about. PSCs is an official term. This is a professional or personal services contract. That's where you're treated like a W-2, you're taxed like a W-2, all of that is fine, but you're not treated like a GS employee for the purposes of longevity and compensate. You're not compensated like a GS employee as a PSC. So all of that is going right now. Like I said, we've won the most difficult battle, which was getting the Court of Appeals to order that the government is liable for overtime and minimum wage for these misclassified 1099s. We've also gotten the court to acknowledge that the individuals who were working for other contractors, for those over at VOA or VOA, there might be names like Techniarts that you are familiar with. For folks that are over at Social Security, names like Carmazzi or Stratcom or ACE are all independent contractors, or rather government contractors that you would have worked for. And what I've gotten the court to acknowledge is that it's what's called a putative employer or joint employer claim, where those folks that I just named, Carmazzi or ACE or Stratcom or whoever, hired, put out notices or put out solicitations, hired folks to either work at Voice of America or UGA or Social Security but once they got you on their payroll and handed you over to the agency, that was kind of the end of their involvement. Your paychecks had their name on them, but as far as when you worked, where you worked, how long you worked, Carmazzi, Stratcom, ACE, Techniarts, none of them had any control over how much time you worked. The agency was the one who told you when to come to work, how long to stay, when to leave, what equipment to use. And so we're putting all of the overtime, what we've argued at the court and what the court has signaled that it understands is that the government is actually behaving like the employer in that instance, and they are the ones that are responsible for making sure you get paid overtime. Most of the time, in all of the instances that I've investigated, the reason that your direct employer, the Carmazzi or the ACE or whoever, didn't pay you overtime or minimum wage in some instances is because their contract with the government did not allow for it. Everyone here who worked with the Social Security Administration is familiar with the $5 an hour, or sorry, $5 per canceled hearing clause in their contract, or how much they got paid. So if they showed up, worked for 45 minutes, worked for an hour, and the ALJ canceled the hearing, they got paid $5. That provision reads in all of the Social Security contracts with the prime contractor, with the Carmazzi, with ACE, with Stratcom. So they were passing along, those companies were passing along to you the contract provision that the government signed with them. So that's why I'm putting all of this at the feet of the government, because they're the ones who actually wrote the contract. So again, for those who are new, like that's the background for the case. The questions I'm getting most frequently now is, all right, well, how do we calculate what we should anticipate? What are our damages, right? So the calculation essentially goes like this. If you were making, $40 an hour, or for some of the Social Security folks, they were getting paid like 37 or 33 or something like that per hearing. You would calculate that in the Social Security universe, we would look at the body of all of the hearings, the universe of hearings. The average hearing which I believe we'll learn in discovery, which I learned from, working for the agency for 3 years, 10 years ago, is about 45 minutes. So we would say, all right, well, that means you're really on the clock for like $40 an hour. And if you're on the clock for $40 an hour and you work 50 hours a week and you didn't get paid for any of the overtime, or you didn't get paid for all of the hours that you worked, let's say you worked 50 hours at $40 an hour, that means you should have been paid $60 an hour times 10, which would be about $600 in that particular week. You could kind of do it on your own and figure out how many hours you worked on average, multiply that number by 2, multiply that number by the number of years you worked, and that would end up giving you, that's the shorthand math to get to your damages number. Now, the reaction I get a lot when I spell out that formula is, well, Joe, I didn't really keep great records. I showed up when I was told to show up. I worked when I was told to work. And my response to that is, it was the government's responsibility to provide a means by which you would clock in and out. If they did not, then that is their problem. And what you will be left with is essentially your word on when you worked against nothing. The government won't have a response for that. Now, the government may try in discovery to say depose a few of you, 1 or 2 of you, and say, well, what proof do you have that you worked those hours? And your answer is perfectly fine. It's what I remember working, right? But there's also things like at the agencies, there's sign-in sheets, there's carding in and out, there's logging onto computers. There's lots of forensic evidence that will support when folks assert that they worked. So we'll use all of that. And what I expect will actually happen in reality is that the Department of Justice, who is the attorneys on the other side of this case, once we have notice out and once there are 10,000 people who've joined this case, what they'll be left with is trying to figure out a number that's big enough to make everybody happy. Because that is what they're facing right now. They've engaged in this kind of employment practice for decades. And in my estimation, it's time for the chickens are coming home to roost, so to speak. So it's time for them to pay. We'll be in negotiations. I'm sure the judge will have a say in what's fair and what's not. You will have an opportunity to speak up if once the government makes an offer, you'll have an opportunity to speak up as to whether that offer sounds fair or not. So I went longer than normal on my normal spiel. So I will say, if anyone has a question now that I have not answered, go ahead and hit your raise hand at the bottom and I'll call on you in the order that you come up. All right. I see a lot of our usual suspects today. We're still doing these hearings. These webinars on a bi-weekly basis. So that means the next time we'll have one. Oh, we got Ignatius raising his hand. Go ahead and what's your question? Ignatius, I can't hear you. What is your question?
Joe, can you hear me?
Yes, I can.
Okay. Thank you for the opportunity again. I just want to highlight some disturbing trend that, we've seen from the current administration. For example, quite recently, we've had a court rule about the administration paying SNAP benefits to those who lost it because of the government shutdown. I believe just yesterday or 2 days ago, the president made a statement essentially alluding to the fact that they may be fine with that directive. So I say that to point to how confident are you that regardless of what the outcome of this case would be, that this administration would follow what the orders of the court is?
Well, I am loath to guess as to whether or not all I'm allowed, all I can, let me say it intelligently. We are operating as if the court, the administration will follow the orders of the Supreme Court. I don't want to get too far into tea leaf reading, but we also just witnessed a special, not a special election, but a 2025 election in which a lot of, I think it was virtual sweep for Democrats in some pretty visible seats like in Virginia and other places. We have the midterms that will happen in 2026, where if the trends continue, I'm not taking a side here because I'm not allowed to, but I will tell you that if history, people say that history doesn't repeat itself, but it does echo. The midterms in 2026 could be a very bad day for the current administration. And if there's a paradigm shift in 2026, then we could see a wholesale change of a lot of different things. That said, I have not seen so far any defiance on the current administration side of anything that the Supreme Court has said. They have been defiant as far as district courts, but when the Supreme Court speaks, this administration listens. And it really doesn't have much of a political choice there because many of the people that are on the current 9-judge panel were Trump appointees. So you look pretty silly if your appointees are making a decision and you refuse to follow that instruction. I also think that, that even as much as this administration has shown a willingness to walk gray lines, or even dance in gray lines, it has not shown a willingness to outright undermine the Constitution in a way that could rattle the republic, which is if the executive branch of government full on ignores a Supreme Court order, that then, whether or not we win this Court of Appeals case or this, our overtime case with the Court of Federal Claims will be everyone's collectively, it would not be our biggest problem. Our biggest problem will be whether or not we have a republic to live in anymore. So I am still holding the faith that, the separation of powers will continue, that the Supreme Court orders will continue to be followed, all of that stuff. So it may be, though, just so we're all clear, and I'm prepared for this, it may be that we have to take a trip to the Supreme Court for something. I fully expected, just so we're all aware, I fully expected back in June of 2024 that the government would want to take its case that it lost at the Court of Appeals to the Supreme Court. It had that opportunity. It passed on that opportunity. It chose not to go to the Supreme Court on this Title V issue. So, I think we're positioned very well. The areas of vulnerability right now, as it relates to the legal side, have to do with our retaliation claim, which is currently sitting and waiting to be resolved. I've told you all more times than you care to hear that we're gonna file a new retaliation claim that is in the works. We're gonna file that long before we blow any deadlines and then get an opportunity. But the reason I'm hesitating is because the Jordan case has some retaliation claims in it. And I'm hoping that the judge will rule on that issue and give me an opportunity to do an interlocutory appeal without having to file a new claim. Because I'd rather, if it's doable, I'd rather avoid having 3 cases run in tandem. But if I have to, I have to. So because the judge gave us some signs that he was going to issue an order around the end of September, I've been, pumping the brakes a little bit on that. So we didn't create more clutter, if you will. But so it's just, that's my hope, like yours, is that, whatever lines the administration is willing to walk, it will stop short of defying Supreme Court orders.
Thanks, Joe. Well answered. Appreciate it.
Of course. What else have we got, ladies and gentlemen? Remember that I'll be posting this video up on the website. I'll send it out to you in an email. We'll have another meeting like this one in 2 weeks. My fingers are crossed that we'll have some more information. You won't have to hear me drone on about the same things again. That we have some more movement from the court. We have some more direction. Maybe again, it could look like another trip to the Court of Appeals on something. I'm waiting on an order on what's called an interlocutory appeal, which allows me to take a fraction of our case up to the Court of Appeals to get an answer on a purely legal question. I've asked for that opportunity on retaliation, and I've asked for that opportunity on the what's called equitable tolling or statute of limitations issue, which you've also heard me call the accrual suspension rule. I'm hoping to take that up and just get the Court of Appeals to rule on that. As far as the overtime piece, like I said, you guys continue to respond to the text messages we're getting. We'll put affidavits together, get those filed with the court, and continue to bolster our case. I'll give everybody one more crack at questions. If not, I'll give you guys your 30 minutes back, and we'll meet again in a couple of weeks. If I'm a shameless plug, if you have anybody that you're 1 degree of separation from that you think could benefit from the case, I will ask you to pass along the forms. I'm going to get that form up for you again and put it in the chat. And then also to pass along the link to the website. Let me drop the form in here one more time. Here's the form. You can grab that form. It's again, it's on the website that I dropped in above. And if that's all of our questions today, I wish you guys a happy Sunday, and don't forget to root for the Bills. See you guys.
Thank you.
Have a good day.